This episode of A Glassblowers Companion is brought to you by Mountain Glass Arts. For the month of September 2019, Mountain Glass is offering Golden Gate Glassworks at 20% off. No coupon code needed, just go there and buy the stuff. And this does not apply to sample packs, combined with other discounts, and excludes 7 and 9mm rods. And for all you beautiful soft glass nerds, they have their Effetre sale at 35% off. Just use coupon code EFFETRE, E-F-F-E-T-R-E at checkout. And for those that don't know what Effetre is, it's a type of soft glass rod brand. And they also have a bunch of sales on kilns and torches. And right now they're doing a $100 gift certificate giveaway. All you have to do is go on to Mountain Glass, use the link, and you can leave a review for kilns and potentially win a $100 gift certificate. They also have some new products like some new trucker hat snapbacks. They're fun styles. I'll have all the links in the show notes. You can also check my Instagram stories where I'm posting weekly all the sales and updates that Mountain Glass is offering, because they do offer weekly sales as well. So any other questions, comments, or concerns, just go to mountainglass.com. That's mountainglass.com. This is the Wise Guy Radio Show, a podcast dedicated to educating and inspiring through conversations with today's top talents in the world of glass.
So hurry back, we would like your company.
Hey, how's it going? Welcome to episode 3 of A Glassblowers Companion. This is your host, Jason Michael. Thank you so much for tuning in today, and thank you so much for the patience in between episodes. It's been crazy busy this last month and a half. I'm trying to get these out every week if I can, but just with my scheduling going on right now, not with work, but just life in general, as this past whole fucking year's been, it seems like it's been crazy, but it's been crazy in a good way. Just moved my fiance down from Massachusetts about 2 weeks ago. We drove straight through from Massachusetts all the way to Florida and got down here. We basically left Saturday afternoon and arrived here in Florida Sunday just before noon, I guess it was. And just before Hurricane Dorian started to, quote-unquote, wreak havoc on us. Unfortunately, she did wreak havoc on the Bahamas, and just keep everybody over there in your thoughts, because I know this is not going to be relevant in a year from now or 5 years from now or whatever. But right now, currently, the Bahamas are dealing with a lot of strife from the devastation of Hurricane Dorian. We were watching the storm and watching the weather, and that thing was a beast. Got up to a Category 4 and then 5, and we're like, holy shit, is there potentially a Category 6 hurricane? Because this thing was not slowing down. It was pretty crazy. And here in Florida, initially the path had it going directly over Orlando, where we're at. So we were pretty much freaking out up in Massachusetts, trying to figure out what the hell the storm was doing. So that's just another really huge reason why, if you're a glass artist, or any artist in general, or just a human being, be prepared for these kind of things. Make sure you have some kind of tub of emergency supplies stocked with water and dry goods and that kind of stuff. I'm not saying be like an end-of-the-world prepper kind of thing, but I did an episode on last year, or 2 years ago, we had Irma come through. Just the idea of having, if you are a glass blower listening to this, to have a studio set up with a tucker tote of some kind of Tupperware thing that you can just put your most important tools and torch and things into, and color supplies and stuff, so you can just pick up and go. And, it's just super important to think about this kind of stuff. But that being said, we were not really messed up too much here at all. Just got some wind and some rain, and she kind of slowly skirted up the East Coast and left rain along the way. And then as of yesterday, we had another disturbance out in the Gulf, or down really in the Caribbean, that was going to potentially move across the state again, and now this one's moving out into the Atlantic. So we're pretty stoked on that. So you just never know, this time of year we are dealing in the peak of hurricane season. And but besides that, just been working like crazy over at work. I've been dealing with my lower back issue still. It's more or less become a sciatic issue. When we had Roberto Beltrami in town from Murano, we were making some really big stuff, and just because of myself personally, just overworking and not using proper body mechanics at certain points in time of the work we were making, I definitely injured myself. And it's been excruciating. My lower back itself has not been hurting, but because it's the sciatic issue, it's been like radiating down into my hip joint, and then down my quad and into my knee and like the left side of my calf muscle on my left side of my body. And it sucks. I can't really sit for too long, which is fine because I typically stand when I'm working. But I have also been working in the hot shop this week and just been taking it easy, making small stuff. And then I'm going to be on the torch today after I'm done recording this, editing this, and going to work. But it's just important, just to make sure you're paying attention to what you're doing out there when you're working, and that you're not overdoing it, and that you are stretching and you are taking care of yourself and staying hydrated, and just making sure you're using proper body mechanics and posture when you work. Because the worst thing you can do is long term is have bad body mechanics and bad body posture, and then injure yourself like I did, and then you are pretty much on your ass for who knows how long. It sucks either way. So. There was not a whole lot of stuff really going on in the glass world per se. I mean, there's things going on. We've got Champs in Orlando coming up soon. I know my dudes from Colorado Color Company are coming out for a little meet and greet. We're going to be grabbing some dinner too while they're here. They're going to be hanging out over at the Orlando Glass Union, I believe they're coming into, for a little meet and greet. Colorado Color Company, if you're not familiar, they make lined and solid color tubing. I've had Sam on the show before, past couple episodes. Goes by Crestbug. Some great guys, and looking forward to working with them further here in the future. We have some ideas and things we had talked about when I was out in Colorado, and things we want to make happen and bring to fruition, per se. Yeah, so other than that, this episode is featuring the highlights from two different interviews I did with Luke Zimmerman. He's going to be coming back on for an updated episode interview, talking about some current laws and things that are changing out there in the industry. Especially right now with the whole vape industry dealing with potentially getting a lot of these flavors, if not all the flavors except for the plain tobacco nicotine flavor, banned in a sense because of potential lung issues people are having. I don't know if it's like one person gets injured so everybody else has to suffer kind of thing, or if it's an actual epidemic going on. I don't vape. I don't really pay attention to it too much, even though I do kind of sort of, because it is part of our industry, sort of kind of all tobacco and smoking related situations. But I'm gonna be talking about that, and just some current cannabis laws that are going out there, and because a lot has changed in the country since Luke's been on last. So the two interviews, you'll definitely be able to tell the transition. I have a little transition in between the two different times that he was on. You can also tell by the audio quality, and it was pretty funny going back and listening to the original episode, interview wise, and just when I thought my audio was good, it was pretty shitty then. And I still, after 5 years, am striving to have the highest quality audio for y'all listening to this. Right now, I'm out in my garage recording. Julie and I do another podcast called FBI Disney that is an adult-based themed Disney podcast where we talk about news and updates and food and our adventures and what have you there. So we set up out in the garage the other day so we can record at the same time, which is actually our first time recording together, which is pretty awesome. We've been recording over Skype, where she records her audio, I record my audio, she sends me the files through Dropbox or whatever, and then we sound like we're in the same room. But now that we're actually in the same room together, it's been pretty cool. Which that also means that I can now interview people in person. Haven't done this. You never really know until you do it how the audio is going to sound, and our audio quality has actually been pretty good. So again, I try to strive to have the best audio quality, but you'll be able to tell the difference with the two interviews. But the first half of this episode, we get into more of the cannabis law talks and some copyright trademark law stuff, really that pertains to the cannabis industry. And then in the second half of the interviews, we get into more of the trademark and copyright in-depth conversations, because it's so important to understand if you're making licensed products and intellectual properties that belong to somebody else, that potentially you can find yourself in a lot of shit, whether you get cease and desist orders, sued, all kind of stuff can happen. So it's important to think about, because I know a lot of us out there that are creatives, we are inspired by specific other intellectual properties that exist out there, whether it's Pokemon or Nintendo or anime of some sort or whatever, Simpsons, you name it. All of these have been influences in our lives growing up, watching these cartoons and stuff and reading the books and comics and the mangas and what have you. And once you learn in glass, it's like, well, fuck, I want to make this into glass. And then you get a response from your audience, and then you realize you could sell this stuff. And even though legally you shouldn't be doing it, it's really hard to say no when someone wants to give you $1,000 for a Charizard. You know what I mean? So it's just things to think about, and the importance of understanding just legal issues that you could potentially come into. So that's part of the goal with this show, is to just share the knowledge, open your mind, expose you to some potential issues that you can run into, and then from there you make the decision on what you're going to do with it. I know myself, having been with the Mouse House for 7 years, I fully understand what it means to have to deal with certain intellectual properties and trademark and copyright and licensing and character integrity and all that stuff, but within the actual corporation sense of things. And just from an outside perspective in another industry that I have, I just, again, like to share the knowledge just so that if you are doing something that you quote-unquote shouldn't be doing, you're aware of just the potential risk that you're taking by doing it. So with that being said, I hope you all enjoy this interview. We definitely will be having Luke on very soon. Him and I have been coordinating some timing. He went to Burning Man. I was moving. He was moving. And, you know, a lot of things happened. So I do look forward to having him on here. We already are scheduled. And he will be a new interview, updated one, will be at the 1st of October. Which is just crazy. He's saying October. Holy shit. It's time for us to start thinking about Christmas time and getting ready for the Christmas time madness. So anyways, I guess that's going to do it for now. I don't want to ramble on too much. Just remember that if you have not left a review, if you listen to this on iTunes, I would love it if you could leave me a review. It definitely helps expose the show in the algorithms of iTunes and the Apple Podcast, giving it exposure to other people out there in the world that have no idea what's going on in the world of glass. We need to expose people out there as much as possible, because I hear all the time how the people think that glass is a dying medium, and in fact it's actually going through a renaissance, as those that are in the middle of it all right now understand what I mean. So that would help out the show tremendously. You can also support the show by sharing with your friends on Instagram, through social media. If you want to do a screenshot of your favorite episode you found, listen to, share it with your friends. Say, hey, check out this podcast. Because I know even a lot of people out there don't even know what the fuck a podcast is. So not only are you exposing them to my show, but you're also exposing them to the world of podcasting and podcasts in general, because there's so much amazing content out there. I'm obsessed with podcasts. I listen as much as I can. And then I have not had a chance to do anything video work-wise or any updates in our Patreon group. But if you'd like to help support the show financially, because this does cost me a bunch of money every month to produce and manage, you can join our Patreon group over at patreon.com/WiseGuyRadio. I'll have all that updated, and I'm actually going to be updating the name of the link and everything too pretty soon, just because I've changed the name of the show. I'm not going with the Wise Guy Radio brand shtick anymore. So for $1 a month, as little as $1 a month, you can help support this show, and every little penny counts and helps out, and everything goes right back into the show to help publish this thing and produce it. So I appreciate that, and I'm going to be also moving pretty soon, staying in Orlando, but moving into Julie and I are getting our own place here. So, and also the house I'm in is going to be up for sale soon, so I got to make sure all my shit's together and packed up. So I'll keep you up to date with the scheduling of the shows, but as of right now, I have one interview in the bank, and then I've got 2 more interviews coming up on Monday, which I'm stoked about. So I'll have 3 weeks worth of interviews already done in the banks. I've got Joaquin coming in from Blazing Heart Productions. We just interviewed yesterday talking about his new documentary that he's doing, which is fucking... We had a great conversation. It's Pipetown, USA, and it's based on the Eugene glass scene up there, which is pretty wild. And also, I've got Mike Luna coming on Monday, which I'm super stoked about. Mike's been a good friend within the industry for a long time. He's been on the show already before, and I've been wanting to bring him back on just to touch base and update on where he's been since the last him and I talked. And it's exciting to see someone who's as an artist who I've looked up to and followed for a long time and watched their work continue just to grow and change, and just continually fine-tuning his stuff. I mean, it's incredible. It's been a lot of fun seeing it. And then I've also got Gibson Glassworks coming on. He's a Canadian glassblower, and we're going to be getting a fun perspective from the Canadian scene. He's up in the northwest part of Canada. And I've had some artists on who lived in Canada for a while, but actually not necessarily from Canada, so I'm excited to talk about that scene. Since Canada has a pretty liberal laws, and I'm really curious to kind of understand what it is like living up there in a place that's a little bit more liberal, even though they have higher tax brackets and different things, compared to what we have here in the States. But that being said, I'm looking forward to getting all these folks interviewed, and then again, we'll be back on schedule. I have my Wise Guy Minute episodes also coming up. That we're going to be spreading things out, trying to make this content for you guys viable and on a regular scheduled basis. So there you go. Hope you enjoy this best of collaborative, whatever you want to call it, highlight episode featuring Luke Zimmerman. I'll have all of his links in the show notes, so if you need to contact a good lawyer, he's based out of California and also Oregon, I believe, is where he's licensed, and Washington as well. So until next time, thanks so much for tuning in. Make sure you stay hydrated out there, and don't forget to leave reviews if you can, please. It really helps out the show. And we'll see you on the next episode of The Glassblowers Companion. Love you so much. Take care. Peace.
I am not representing anyone who is hearing this podcast. I am a licensed attorney out of California. Any of the information that you're going to hear me discuss in this podcast is merely my opinion. This is not a legal opinion. This is not something you should rely on. If you feel like any of the issues that I discuss or any of the information is something that might apply to your business or you personally, seek out the representation of an attorney. I am not incurring any liability from this. We are not having an attorney-client relationship, and just listen to this for entertainment, and if anything comes up, we'll go from there.
Because the glass culture used to be something that was more in the background of everything. It's always been a strong culture as a subculture, but it's becoming more and more a forefront.
Yeah, absolutely.
And with that, traditional businesses are starting to take attention to what this industry is doing.
Yeah. I agree. Like, and especially with the branding that's going on now, and with the bigger name artists that are becoming a brand. It's like Versace and Gucci. We've now got Elbow and Joe Peters. It's like, it's pretty freaking cool.
The thing to remember is the reason that people use names, they use an alias. Mm-hmm. That's what it was.
Yeah,
it
exactly.
was a moniker as not to hopefully get arrested for what you were doing. And so for where I'm standing from a trademarking standpoint, when an alias is no longer really an alias, it can become a brand. Mm-hmm. And what you've been doing is building a brand, potentially unintentionally, for the majority of these artists' careers. Yes. That because most of the artists, it's not that hard to find them. Yep. If you want to track down, especially some of the bigger artists, finding their phone number or finding a contact for distribution is not that hard. So if it's not an alias anymore, really looking at it as a brand. And so now what you got to do then is treat it as a brand and protect it as a brand. That you get some built-in common law protection, but you got to do some secondary steps to really protect yourself as a business and as a name that has been developed over the years. Because if you think about it, some of these pieces that, we'll say sell for $1,000, the value in some of those cases aren't necessarily just the craftsmanship that goes into the piece or the skill or the beauty, the excellence. It's actually the name also that people will buy off of brand name recognition. And with that, because, you can see some up-and-coming artists who are making amusing pieces, but are still having a hard time selling. And then there's some artists who have a really developed name who can sell anything they make.
Yeah, exactly.
And a lot of that is off of brand recognition, which is only going to become more and more important. in the glass culture.
Yeah, especially with social media, because like most people know your glass or your social media feed by your brand. And like when I was trying to think about, but like with my podcast, I created a Wise Guy Radio podcast page because I wanted to do exclusive things there and bring my followers there. But like my audience is under my J. Michael Glass page. Like, my 9,000 plus followers I have, it may not be all, maybe only 1,000 of them, in all reality. But,
right.
The fact of the matter is I've found, I launched a page. I said, hey, come follow me, blah, blah, blah. And I got like 150 followers, which is awesome. I'd take one. But the fact is, my brand is, for my glass right now, is under the J. Michael Glass. But my item that I've created, my trademark for me personally, I feel my owls that I've coined the Wise Guy brand name, that's now my brand.
Right.
So I'm like an artist with a brand in a sense, and
right.
it's like it's a whole different weird thing because like I'm an artist. As an artist, I make chandeliers. I do other things as well where when I make them and sell them, it's really good money. But then my full-time glass me is the Wise Guy brand. So I'm trying to I've got multiple personalities that I'm playing with, almost like two different separate artist corporations or whatever, It's an interesting setup.
And that's, because some of the artists who are really famous right now, Joe Peters is a great example. We know Joe Peters is Joe Peters. Whereas, we'll use an example, I'm trying to think of a great, Salt.
Mm-hmm.
How many people know Salt's real name?
Right. Yeah, exactly.
Do they know Luke? Did they know Lucan? I don't know.
Yeah.
And when you have that separation, there's different steps that you need to go about protecting yourself with that, especially protecting a brand. And I have seen some areas where there are more and more room for trademark infringement going on just between artists and names, let alone the underlying issue of trademark infringement from the glass culture pulling on popular culture, or we'll say non-glass culture, and seeing trademark infringement happen there.
Yeah, and that's my concern.
There's got to be an awareness of that.
Yeah, I agree.
So I think especially Instagram is a big one. A lot of the hashtags, a lot of the ways that developed businesses will police their brands or their companies is they just search hashtags that relate to their company. And if you're making a piece of glass that is intentionally or unintentionally capitalizing on one of these established businesses, I've seen some cease and desist letters that will be a problem for you, especially if you're making if you have a creative line of glass that you're making that is essentially recreating something that already exists for another company, you're inevitably going to have a problem.
Yeah, it's huge. The Kool-Aid Man that was going on for a while, that's an obvious trademark violation as a mass-produced piece that's now coming out of China, or was. I don't know if it still is or not, but that's it's an awesome idea. It's a great functional piece, but it's a fine line.
And that's if you can make one of those that's beautiful and you want to make it for yourself, that's not really as much of a problem.
Mm-hmm.
If you're going to make them and start selling these as this is your bread and butter line of what I'm producing, you have a serious problem.
Okay.
You are, actively engaging in trademark infringement for a financial gain, because the underlying idea is you didn't create that concept.
Right,
you're replicating that concept in a new medium. Now, with that, you're pulling off of somebody else's hard work, and that blatantly is infringement.
Mm-hmm.
Granted, we're kind of mincing words here on trademark infringement and copyright infringement.
Right.
But yeah, you are taking someone else's intellectual property and capitalizing it for commercial gain, which you will, especially for an established business, you will find problems down the road with that.
So what about character work, for instance, with that? Because I know there's that certain percentage. If it's changed just a certain percentage, they can't do anything necessarily. They may still be able to, but...
I would argue, especially if you're getting into fair use, parody, any of these things, right now, you got to remember the glass culture, especially if you're just talking about pipes, isn't going to necessarily get the same protection you would get if you were doing a painting. It's not perceived in the same way. Copyright law for artistic expressions protect artistic works, so sculpture, painting, music, movies, one of the exceptions to this is it does not protect functional design. Now, I have talked to a few attorneys who've been practicing far longer than I have about the concept of can you protect a glass pipe with copyright? And there is a lot of mixed opinions on that right now. So if you don't even meet the level of something that would be protected from a copyright protection aspect, if you're doing an infringement, you're not even going to be able to bring up the argument of defense for fair use or parody. You don't even fall into that category anymore because you're not even in the copyright area.
So because of it's illegal paraphernalia per se.
But really because there's function. If there's function,
okay.
You can't necessarily get a copyright. Copyright has to just be an artistic expression.
Okay.
And I would love to see this. I think there is probably room for a really good law review article about the impact of, sculptural design in the pipe culture. And is that protectable? Because there is a whole process for trying to separate design and function from artistic expression. But I don't know of anyone who's really gone to bat for that yet.
Interesting.
And try to register a pipe with, the federal government as in the form of a copyright. I don't know of that yet.
Huh. Okay.
So that anybody listening, if you have a piece that is incredibly beautiful, heavily weighted on the sculptural side in a very, very artistically done manner, and you want to take a crack at that would be something I would have to discuss with you.
Interesting. So even if you made a frickin' teapot, for instance, that looked like...
Teapot, you're probably not going to get... that's a sculpture,
right,
arguably, but you're probably not going to get that copyrighted because it's the function of a teapot.
Because it functions, right.
Now, you can get into it's not a cut and dry matter because if there's enough artistic expression on the teapot, you might be able to get the design or artistic expression protected, but you're not going to get the function of a teapot being a teapot protected.
Okay, because like Disney, for instance,
right? Part
of my business, I follow them as their marketing. They got every freaking thing right now frozen from, the movie. Olaf freaking rain gauges, towels, sweaters. So the original design of that character is trademarked and copyrighted based on when they originally created him. Everything therefore after that's created and merchandise, is that more than on the trademark side of things because it's a trademark character of...
That would be, in my opinion, more of copyright issues.
Okay.
Because, you can argue that, I don't know if you'd want to call it derivative work, but it's based off of an existing character that was authored.
Right. That was and copyrighted.
Right.
Okay.
And so that would be, in my opinion, much more of a copyright issue. Just as, for glass, if you start pulling out popular characters and recreating them from movies, TV shows, you're recreating them in glass, you're looking at a copyright violation. So that's something to be very aware of because I've seen a lot of this go on, and I think in the past it just kind of flew under the radar because major businesses didn't brush up against the glass culture. But now, especially through things like Instagram, it's a lot more accessible with the hashtags. That is one I encourage people to stick well away from. Don't recreate popular characters.
Yeah, because the same topic. Not okay. Now we're gonna put the copyright stuff away. Right. If a 5-year-old kid's on Instagram and they put in hashtag Kool-Aid Man and a rig pops up, that's for 18 and up purposes. Then we're in a whole different freaking ball field with it. That's like it's like you're in a whole different thing.
And that's there's two ways of looking at it. One, so we're done with copyrights, and that we're not just saying you're using a pre-existing thing for commercial gain.
Right.
But for the idea of if it is akin to a trademark, if that character represents a trademark for that company, you're devaluing that brand. And if that brand is targeting children, so, you will use an example of Disney, because Disney is targeting children. And if you are now injecting a good that is capitalizing on one of their trademark aspects, that there's a possibility the parent would think, oh, wow, Disney now is engaged in creating pipes.
Mm-hmm.
You are seriously devaluing that brand and causing brand confusion. With that, you don't want to find yourself in that situation either.
Yeah, it's a whole other thing. It's huge.
Especially with children.
Yeah.
And it's just removing this just from the glass industry. I mean, anything in the cannabis industry right now, if you have a marketing plan where you want to do anything that's colorful, creative, be the Willy Wonka of cannabis, whatever it is, I encourage you not to do that. You are going to be, even if it doesn't happen right away, you're walking towards a lawsuit. Anything that could be perceived as targeting children, you should avoid, let alone if it's already existing and you're capitalizing on someone else's intellectual property. But just anything that is cutesy like that, you're creating a problem for yourself.
Yeah, I agree.
Yeah.
Yeah, because look at the tobacco industry. I mean, they were nailed. All their, you don't see any characters, billboards, anything anymore. 100% across the board. And for us, it could be terrible. It'd be ramifications for that.
It's taking a big step back that we don't need right now.
Yeah.
I mean, depending on how old you are and you're listening to this, maybe you remember Joe Camel.
Oh yeah.
And what Joe Camel was, the way that went down was you are intentionally targeting children. We do not need anything like that. I mean, maybe the hands bear too. Hands of sky with pure blue waters. Yeah. I don't know if the bear is represented either. That anything that's cartoony or kitschy, that is going to happen in the cannabis industry.
Yeah.
I mean, there's already issues with that for advertising, and we'll get to that in a little bit because there's some interesting stuff on the state laws for cannabis accessories, I think we'll call them in some states.
Yeah.
But especially tied in with advertising, and what is acceptable to be advertising, who you're advertising towards, what age range is acceptable. That is very much going to affect the pipe industry also, or the glass industry.
Mm-hmm. So the biggest piece of advice I guess we can give our audience is if you have an Instagram account that has anything at all ever mentioning or has to do with anything in the cannabis industry, have it on your thing saying 18 and up or even 21 and up, and make your account private.
To be safe, I would argue 21 and up, I would keep it private. Because trying to police that, I mean, if you're being followed by someone who's 16 and they somehow get their hands on a piece, I'm not saying it's going to happen, but you do open yourself up potentially for a lawsuit, especially depending on what the design looks like. I mean, if you're making really colorful dragon, we'll say, it looks like a cartoon.
Mm-hmm.
You are potentially just really creating a case against yourself.
Yeah, it's like my owls. They're cutesy and stuff.
Yeah, they're cute. I mean, those owls are really cute. So it's like, now, are you intentionally targeting that to your children? No. But if you've got a concerned parent who found that in their kid's hands, and especially depending on the state you're in, that's even more problems. But if you're creating identifiable characters like that, you really got to be concerned about where that is in relationship to children.
Yeah, interesting, because I know, like, I've taken pieces that I had an issue with, like my owls, for instance, and I saved it by ripping open the bottom and then making it big enough to fit a little tea light candle, and then I sell them at craft shows. These little owls that are like night lights, but looks exactly like my water. It's the same. It's my water pipe, which just serves a different function. So I guess in terms of if I want to brand out as, like, say, trademark and copyright my brand, my Wise Guy brand, I've got to be extremely careful with who and which direction. I have to go, I can't go both directions, it seems like. I can only either go towards the craft family shit or go completely into the adult industry, per se.
Yeah, well, I mean, as long as there's a few different ways to approach that. It's not as easy. You're in Florida. There's already some restrictions on how you'd approach that just at a state level.
Mm-hmm.
I think if you wanted to pursue a trademark for creating smoking goods for tobacco use, so long as in good faith you're making these goods that is your intended purpose of how they're supposed to be used, arguably you could pursue a trademark.
Okay.
Yep.
Yep.
And I think, that actually dovetails pretty well into talking to you about, you'd ask me a question, is it illegal to ship pipes through the mail across state lines?
Yep.
And I did, a little bit of research on this to use the exact words. So we're looking at U.S. Code 21, Title 21 of the Controlled Substance Act, which states it is unlawful for any person to sell, offer, sell drug paraphernalia, to use the mail or any other facility of interstate commerce to transport drug paraphernalia, and to import, export drug paraphernalia. Now, right now, at a federal level, drug paraphernalia is defined as broadly under Section D, but pretty much anything that is used to introduce marijuana, cocaine, hashish, hash oil, PCP, methamphetamine, amphetamines into the human body through things such as pipes, hash heads, glass, stone, plastic, ceramic pipes, pipes without screens. Now, if you are making products with that intended purpose, you are still engaged in the act of creating drug paraphernalia, if that is your intended purpose when you create that. If you are shipping that across state lines, that is still illegal under federal law. There is a grayer area when you start to define what drug paraphernalia actually is, where, I don't know if people are familiar with the obscenity laws, but it's the whole I know it when I see it kind of relates a little bit to paraphernalia also. There is a list of 8 factors that are used to determine if it constitutes drug paraphernalia. Not all of the criteria have to be met, but it's kind of on a case-by-case basis of, is it what we think it is? And that's why the first one is, what are the instructions for the good, oral or written, provided at the time the item is purchased? Number 2, descriptive materials accompanying the item which explain or depict its use. 3, advertising. 4, manner in which the item is displayed for sale. 5, whether the owner or anyone in control is a legitimate supplier of like-related items to the community or is a licensed distributor or dealer of tobacco products. 6, direct and circumstantial evidence of ratio of sale of items to total sale of the business. 7, existence of scope of legitimate use of the item in the community. And 8, expert testimony concerning the use of the item. Now, depending on what you're making, I would be including in all your sales that this is a tobacco good. My intended use, if it's not just purely for sculptural and for beauty and appreciation of art, is there is a disclaimer that this is intended for tobacco use. I think that is one of the biggest things any producer of glassware should include, and especially in all sales, especially in all packages that would traverse state lines.
Yeah, I agree.
The thing that really is a standout, though, for the 8 factors that I just listed, there is exceptions to this, and exemptions, which are interesting because this really impacts where the state of the industry is today. Is the first one is any person who's authorized by a local, state, or federal law to manufacture, possess, or distribute such items. Number 2, any item in the normal lawful course of business is imported, exported, transported, or sold through the mail by any other means and traditionally intended for use with tobacco products, including a pipe, paper, or accessories. Now, that is how a lot of the industry has been able to survive to where it's at today. Of those 2 points that I made, the first one is probably the more interesting one because this is the one that's changing. Any person authorized by local, state, or federal law to manufacture, possess. Now, there's a separation here because there are 4 states that have amended their laws to allow goods that are made for cannabis consumption not to be identified as paraphernalia anymore. So there's a gray area here of, would the federal government honor that? because it's still federally legal as the initial definition of drug paraphernalia that I put out, anything used to consume cannabis, cocaine, hash oil. But now you have states that are saying that you can do this. I think this is one of the reasons why you've seen a lot of glassblowers flock to Colorado. Which makes sense. I mean, that when you have a state that all of a sudden says that this is a legitimate industry now, and you feasibly could even, in some of those states, probably market your product directly next to a pile of cannabis. Now, if you're shipping those pieces across state lines, I think you have a serious problem, especially if you have any advertising that directly relates to cannabis, because you can't, in good faith, then argue, this is intended for tobacco use.
Yeah, yeah, that's true.
But this is a changing issue, and it's kind of an exciting time because there are certain states that I think you could probably live in as a glassblower. Probably a little bit. Your chances of having confrontation or run-in or prosecution from law are probably less in Oregon, Colorado, Washington, and Alaska right now. Just because they've amended their laws. And what is unique is each one of these states has amended their laws in different ways to address the issue of what is considered paraphernalia and now what is considered a lawful good. Colorado, for example, and Amendment 64, Section G, marijuana accessories, now anything that's used for storing, vaporizing, containing marijuana or ingesting, inhaling, or otherwise inducing marijuana in the body can be considered a marijuana accessory. It's not considered paraphernalia anymore. So long as you're producing that and keeping that in state, you're arguably, you're following state laws. You still might be in violation of federal laws, but you arguably wouldn't have an issue with local authorities.
Great, yeah. That's always my concern is once you cross state lines, it becomes a federal deal.
Right. So, yeah, and it's interesting. I mean, if you look at Oregon and Washington, both of them, those states have amended their criminal code. More so, they just went in and crossed out sections which would constitute cannabis as being drug paraphernalia. But they kept it mainly in the area of the criminal code, whereas Alaska and Colorado both took the approach of redefining what marijuana accessory is as opposed to paraphernalia.
Interesting.
So that's just some differences. And I mean, the other thing that needs to be identified also then is because these states are 21 and over for cannabis consumption, you're only supposed to be selling marijuana accessories to people who are over the age of 21. So if it's intended use for tobacco, you should be able to sell it to an 18-year-old who can legally consume tobacco. But if it's an intended purpose of consuming, a cannabis or a cannabis product, that is only supposed to be for people over the age of 21.
So if you live in the states that are legal, then you have to get an ID to make sure they're 21, because
I would take that. I think that is being proactive for following the law.
Yeah.
I have not. There's so much confusion about implementing a lot of these cannabis laws that I haven't heard anything about paraphernalia implementation yet for the law. But I think that's on the horizon after this settles down a little bit. Just because I think it's a secondary issue just behind the actual possession of the plant or, a product derived from the plant. But I think it's on the horizon. I think this is going to get tested. I think it's something to be aware of. I think somebody is going to get in trouble for selling an oil rig to a 19-year-old. I think that'll happen.
So crazy. Yeah, it's just something to think about. And just everybody's. That's why I wanted to bring you on, brother. Times are changing, and they're changing for the better. Come the next presidential camp, the whole next presidential thing. Who knows what the hell's going to happen? Hopefully, it just gets better. But it's interesting to see where this all is.
Right. Well, and this is a thing to consider too. So, like in Oregon, following at least with the bill, Oregon and Alaska are still working on their implementation yet. But Oregon if you're purchasing I want to get this right. So I think this would be called marijuana paraphernalia, which is legal under Oregon law. You also have to have an explanation of how the product's supposed to be used. Now, that would fulfill the federal standard for how they define paraphernalia under sections 1 and 2. But what that also then does is, if you have a description of how to use an oil rig, you have a written description, oral description of how to superheat a titanium nail. If that hurts someone, you are opening yourself up for room of a product liability case, which traditionally has not been anything anyone's talked about in the past. But if a piece explodes or someone gets cut or someone gets burned, you could face civil consequences due to this, because this is a legitimate business now.
Yeah,
this is
absolutely.
Not something that's, in the background. This is something that is in the forefront. That I think a lot of people need to consider that, especially when coming up with new designs or doing product testing. If this is something that feasibly someone could get hurt by using, it's not. You really do open yourself up to a lot of liability from that.
Yeah, it's interesting. It's like, it reminds me of like when McDonald's was sued for the burnt coffee, the hot coffee thing. Old lady hot coffee in her crotch deal, and she sues McDonald's for like $10 million, where the hell it was. So if you guys burn yourself with your nail, don't sue any companies. It's your own fault.
Well, and that's the argument is it's not necessarily your own fault.
No, I know, absolutely. No, I agree. I'm just saying.
If it's reasonably foreseeable that someone could have hurt themselves by using your product, and granted that's a very watered down way of understanding product liability theory, but if it's reasonably foreseeable that someone could hurt themselves in that manner, you potentially owe them or could end up owing them damages.
Yeah. Well, like we just had a guy here in my town that had a vape cigarette, or whatever, explode on him. The guy was a war veteran. He's like, I survived all these, tours of duty, and I almost get taken out by my vaporizer pen, for his tobacco stuff. And
right.
Literally the thing got too hot or something on his charger, and it exploded. It's like,
yeah.
But because it's made in China, he can't do shit about it.
You can, actually. Product liability, the theory states, both the producer and point of sale are accountable and liable for damages.
That's what I thought. Okay.
Feasibly, the vape store, or, if he ordered it directly from China, that's a lot harder to try and argue. But if you bought it from a local retailer, you arguably have, potentially, a claim against that store. Because if they're selling faulty goods, the liability extends to them also.
Interesting.
And I think there is going to be so much of this on the horizon. Looking at the glass industry and looking at cannabis culture, that for some of the conferences I've been to, for what we talk about as lawyers, looking at the future of what people will be dealing with, I think there's going to be a lot more business formation issues. There's going to be a lot more intellectual property issues. But the next wave is going to be a lot of lawsuits. And a lot of, especially anything that's making medical claims, you're going to find lawsuits. Anything that somebody in this gets directly hurt from using the product, where before maybe it was, walk it off, or I don't know who I complain to, or how do I hold someone accountable? Now you can have businesses held accountable. You can have individuals held accountable in a civil court. It's not just a criminal action anymore.
Yeah. Huh. Fascinating.
Yeah.
I don't even know what to say.
I think it's a big one to digest, just because that has not been traditionally how a lot of this culture is operated. People haven't thought about that. It's like, okay, if a piece broke and someone got cut, it was like, oh crap, that sucks. Maybe a piece got replaced, maybe it got fixed. But no one was talking about potentially covering medical bills or medical expenses.
Yeah,
I've never heard of that. That is much more a reality now. That is on the horizon of happening.
Well, it makes sense, man, because like the way the community's going and the culture's going, it seems like these type of conversations between myself as a glass artist and yourself as a lawyer who represents and is a friend of our community, like these conversations need to continue to go on in groups, in forums and mastermind groups and stuff to really see, because like it's gone, like you're saying, it's gone from underground, and then Operation Pipe Dreams happened, and it went even further underground, and then it all of a sudden just came blown out of the ground. Where like we're talking about how like our aliases has become our brand names, to now with legalization in states, to now candies and chocolates and brownies and everything else that's being produced out there. Not even to mention the stuff that is being consumed by smoking it. And now we're dealing with liability issues. And I mean, it's like when the cell phone came out, they didn't think about people probably texting and driving and killing people on the street.
Oh, yeah.
Now we got to deal with the same shit now with pipes, because it's such a forefront. That's why, like today's show, I was all about, y'all need to pay your damn taxes because this community is getting, viewed by the IRS because of how big it is, how the monetary value is going through the frickin' roof. And they see that this is a multi-gazillion-dollar industry that is now wide the fuck open in the eyes of everybody. They know we're doing this. Doesn't cover our ass now, not be stupid.
Yeah, and I think, from talking to a lot of artists who've gone into glassblowing want to just be artists. Mm-hmm. And I respect that. But I think at this level, you need a good support team. I don't expect everyone to know how to do their taxes or how to file business taxes, just as I don't expect you to know how to file a trademark on your own. Mm-hmm. But there needs to be an understanding that you do need this assistance. I mean, and inevitably, especially at some point, being able to find insurance to back up your business.
Yeah, absolutely. I agree.
Because you're like any other product now, especially depending on the state you're in. There's obviously some states you're not like every other product yet, but that is, I think, the way this will go. And that's the trend that I'm seeing. And with that, you'll be treated no different than any other business.
Yep, absolutely.
And especially, I think the biggest way this initially will get tested is through the vape pens and through the electronic vape pens. And it's similar yet different to just the glass industry, but these are the areas that I think that the first big round of lawsuits will come from, just because of the issues of heavy metals, the issues, like you mentioned, of the guy who having these things blow up. I mean, those stories are not uncommon. Yeah. But that's only, now let's move that over and seeing someone get hurt from a hand torch, seeing someone get, a nail or a rig that gets heated too hot and kind of blows up or cracks. Those are going to happen also. So I think, and I think this industry, to use a comparison, I like to consider the glass industry as entering its teenage years, I think, where the cannabis industry, I use the comparison, the cannabis industry right now, because they have lobbyists, there's some really great trade organizations advocating for the direction of the industry, that the cannabis industry is kind of driving the car, and the glass industry is riding in the car with the cannabis industry kind of in back, like an infantile kid that really doesn't have a lot of input about where the car is going, when the car stops, what they get for food. They just are kind of along for the ride right now, and they're benefiting from it because they get to go on the trip, but they don't have a lot of input on where it's going. Mm-hmm. And I think it would be a huge shift to get the glass culture into the driver's seat. I don't know if that would necessarily happen because it is so dependent on how the legalization of cannabis and the cannabis industry is developing. But I think there's a lot of room for the glass industry to sit in shotgun and have a lot more input on how this is going and have more of a adult conversation about what its needs are and how to have it represented adequately in the developing law.
Yeah, I agree. Yeah, it's no longer are we there yet. It's how can we help you get there and help us get there reasonably and professionally, because we're going to be the next freaking not Walmart as a brand wise, but I mean as a big entity in terms of they're going to be everywhere. Eventually every state's going to be like this.
Arguably, there's going to be only an increased demand for these products. Mm-hmm. And I'll say, for having been at a number of the suit and tie kind of cannabis industry events, bringing up the glass culture. I don't see any of the faces that I know from the glass culture showing up at these events.
Yeah.
And there needs to be a voice. There needs to be representation there. And talking to a lot of the people who are really helping push or develop the cannabis culture in the cannabis industry, cannabis law, cannabis lobbying, bringing up glass, they just kind of, it's not laughable, but they're just like, it's not even on my radar. Like, that's not what, I don't care about that. Like, that's a secondary aspect of it. Seeing that there's so many people whose livelihood they've invested into this, there needs to be more representation.
Give me a heads up, bro. I'll be there. Let me know.
All right. Well, the big one, I will say, if people want to get involved, the NCIA is something that would be really, really good for people to get involved in, especially people who like to be an advocate, people who like to have more of a dialogue. But yeah, I think there needs to be a lot more of this from the glass culture. And I think with that, if the glass culture steps up to that challenge, the likelihood of making this more palatable, where you have gallery events and there is more perception of it being an art form, there's a lot more room for that.
Yeah, I agree.
That because it will be perceived as more of a mature industry.
Yeah, exactly.
And I think that's happening. I mean, it's to a certain extent it's happening either way, but it would be on its own terms. And that, I think, is immensely important for any industry, when they define their parameters.
So we are going to be talking about trademarks today. And I know you and I have in the past talked about copywriting or trademarking logos and names of businesses and even maybe lines of work as well. So I'm really curious to see what kind of stuff you got to talk about and see what we can fill in the blanks here and some of these questions that people have out there.
Yeah, trademarks, especially for the glass culture, are becoming more and more of an issue. I think I've seen a number of more disputed name usage. I've seen more cease and desist letters. I've seen cease and desist letters come from non-glass industry coming into the glass industry, especially if people recreating more traditional products in glass, and a lot of problems stemming from Instagram in that regard, where if you use the wrong hashtag, especially of a trademark product, you're going to find yourself having a problem.
Yeah.
So I'd like to think of this episode as really addressing trademarks in both a proactive way of protecting yourself and protecting potentially your trademark, but also being aware that how you're marketing your products could be opening yourself up to liability of a trademark infringement, where you think, this is something fun, or I'm making a sculpture, or I'm playing up on a brand that already exists. There's a possibility you're going to find yourself getting a cease and desist letter from companies that have more money than you do and are willing to squash anyone who's using their trademark without consent or without permission.
Yeah, it's fascinating. So just kind of real quick, one question I have before we kind of get into all this. So if I was to create a trademark item in glass and I didn't sell it, I'm good to go. But once you put it out there in the market is when you start to have issues, basically, right?
In my opinion, if you create something that's trademarked, and so long as you don't put it into commerce, you're not trying to generate some sort of profit from it, I don't think you have a problem. It's no different than creating art for your own personal appreciation, your own personal satisfaction. It's something you're not trying to monetize and derive gain from. And the idea of a trademark is protecting something. It's kind of a twofold. It's one, protecting a consumer so they know the point of origin for a good or service, and they know that they can rely on it. And then two, protecting a business where going ahead with a business model, a product, or offering a service, it can protect the business because it identifies the product or the service that the business is providing and restricts other people from using the name, which might cause confusion to their consumers. So if you're making it for your own personal appreciation and you're never selling it, Yeah, I think you're more in the direction of not having an issue. Where this would get interesting is you make it for your own personal appreciation, but now you want to display it. And if it's being displayed and there is some amount of financial exchange to see the goods that you've made, you're actually engaging in a commercial transaction then.
Okay.
So it's not just a yes or no, but if it is just for you to have at your house and appreciate for yourself, I don't think that would have as much of a problem.
Cool. Yeah, it makes total sense.
Yeah.
Awesome.
So the things, the way I would like to break down this episode too is when looking at a trademark, there's 4 things that you really need to consider. 1, is your trademark protectable? 2, is it already in use? 3, can you get your trademark registered? And 4, special concerns we might be seeing for pipes and trademarking. Trademarking is not new to the glass and pipe industry and culture. Many of you might not be aware of this, but companies like Mothership, Hitman Glass, Swiss Perk, Graphics all have federal trademarks, or at least applied for federal trademarks. While it's not glass, most of us are familiar with raw papers. They also have a federal trademark. So these are being pursued by a lot of really legitimate aspects of the industry. And in my opinion, it is the future, especially if you're developing a brand, that you want to have protection for it. So moving ahead with that is essential. You get common law protection just because you're using it, but really that doesn't amount to a lot of protection. So federal registration is ideal. So yeah, that's something for, I think, every artist to consider. I made this comment in the last episode, and I think it's still applicable, especially applicable in this episode.
Yeah.
The aliases of the old days that allowed us to move through the industry more anonymously have become your trademarks. They are, in many ways, the way consumers find you. They are the brand identity that you have. They are having more so than even just the name. It's the feeling, the lifestyle brand, however you want to call it, surrounding what that name is. And consumers gravitate towards products based off of that. So if you've been operating under an alias, consider looking into this. I think it's important. And actually, one other glass artist who has multiple federal trademarks is Chihuly.
Yes.
That he even has his signature trademarked.
Right.
That I think, especially for any glass artist who understands the value of what that means and hopes or aspires to grow to a size that would be comparable, it's just, this is part of doing business. So
yeah, I agree, man. When I was working the Chihuly collection here in town, I studied a lot of his business practices in terms of his marketing from the very, very beginning. Now he's a brand, he's Chihuly.
Well, and that's it. As the name grows, the value of that trademark just increases, and that's oftentimes when you think about the valuation of major corporations, about where the actual value is for, like, Coca-Cola. You're going to argue, well, they own factories that produce these things. They own chains of distribution. They own apparel. Really, arguably, the most valuable aspect of Coca-Cola is the name Coca-Cola.
Mm-hmm.
Because you can put it on anything and you'll have consumers buy it because they identify with the brand. That is an incredibly powerful aspect, and it's their trademark.
Yeah, exactly. Yeah.
And I think Chihuly has that same experience where, you start out as an artist, nobody knows who you are. And after you start getting that growth, people will gravitate and buy your goods just based on the name. And as people start buying these, especially in the art world, you can start adding zeros onto your work, and they only get more desirable. And I think we are seeing that in glass culture now. I think especially in Colorado, there's a lot of great examples of high dollar pieces moving that are really based off of identifying with an artist's name.
Yeah, man. On that same note, it kind of came to my head here. I want to cut in if you don't mind.
Oh yeah.
On the whole Coke brand. So like, anybody asks if you want something that's bubbly and sweet and carbonated, whatever soda, you say you want a Coke, no matter if it's Coke or Pepsi or Mountain Dew. It's like just like the way that brand has come into our language and our culture on a daily basis. Some places it's pop, some places it's soda, but down here in Florida, we say a Coke.
I was going to say that is very regionally based.
Right.
And actually, that touches on a very interesting dilemma in trademarking, because Coca-Cola, and this is actually the first section we're going to talk about, is it protectable? And I'm going to use it as the example. So let me explain this concept really quick. Is it protectable? When you assess, and the United States Patent and Trademark Office, their officers will do this when a mark comes in. They'll assess, does it rise to the level of being a protectable trademark? And there are 4 identifiable categories to assess this. They're called fanciful and arbitrary, suggestive, descriptive, or generic. The most powerful protection will come from fanciful or arbitrary. An example of this would be Apple computers. Prior to experiencing the product, if you just saw Apple, you'd have no idea what that was. But as soon as you experience Apple computers one time, as soon as you hear Apple, you're going to have that association. Now you immediately think of the fruit, but you're also thinking about the computer. Prior to you experiencing that product, you didn't have that association. It was totally arbitrary. The name does not give any reflection of what the good or service the company is doing. Why this is really exciting for the glass culture is most aliases or most names used by glass artists, you'd have no idea that they were glass artists.
Right.
Ghosts, salt, you don't know. And that actually is one of the best ways to seek trademark protection. Your chances of getting it granted are really high. The second level is suggestive. An example that's used by the USPTO is glance-a-day calendars. Now, Coca-Cola would fall into that realm where there's cola involved. You've had Coke, they might have come up with that. So Coca-Cola, it's suggestive. We know what the product is. Descriptive, arguably Coca-Cola could have been descriptive. That's the third category. Fourth category is generic. So Coke has to be incredibly diligent policing their intellectual property and the use of their trademark, because if a trademark gets used to the point where it is just common speech, it's not protectable anymore. Even if it was arbitrary or fancy, it can revert down into being generic, which is a very nuanced area of trademarking. But the best example is Xerox, where Xerox is a copy machine. And really, we got to the point where we were just saying, oh, would you Xerox this for me? Even if we weren't using a Xerox machine.
Right.
Because it became so commonly used, that made it generic.
Well,
Actually,
oh, sorry. Go on.
Oh, no, it decreased the value of the protectability, not the value, the protectability of the trademark.
Okay. Well, that's why I brought it up, because just got me thinking, like right now it's a silly fad trend thing going on, but Q-tips, are being used, and Q-tip jars are being sold for thousands of dollars. But they're using the term Q-tip jar. Now, we all know Q-tip's a brand, but what you're supposed to use the thing for is not to go in your ear, but whatever, that there's all kind of weird shit. But what they're using it for in this industry, obviously, is to clean out a nail or something like that.
Right.
So that kind of correlation of the legality side of things, along with also now you're using a trademark name that's still a generic term being used for something that is cotton on both ends of a stick, So I'm thinking, it's like, how do you run along that? Can they sue you for saying, hey, I'm using this container to hold your product that's being used for something potentially illegal, depending on where I live in this country? It's crazy.
Q-tip has gone the way of Xerox, where it's become so common that it's much harder to protect. I mean, people will buy Q-tip brands over other brands of cotton swabs on the basis of name recognition, but trying to protect that, because now all cotton swabs are Q-tips for us.
Exactly.
We use it interchangeably. The protectability of that has gotten really problematic for that company. It's one of these things where you can become so successful or so prolific with your product or service that everybody just uses it. I mean, Google fights with this all the time.
Yeah.
Because, hey, why don't you Google that?
Yeah, exactly.
Well, really, you're searching on the internet. You're doing a web search. That's the actual function of it. But they've become so efficient with their product, and we've relied on it so much that we use it for everything. You might be using Firefox, but you're still Googling something.
Yeah.
Just because it takes on its own meaning. I mean, so that's something you got to be aware of. I don't think we have anyone in the glass industry that has gotten so. I mean, for a period of time, arguably back in the day, graphics, when there was just the boom in pipes and accessibility, graphics really had a good chunk of the market. Where, at least for being in Wisconsin growing up, you just assumed that if somebody had a tube, it was probably a graphics. There just was not, they were a step above generic, and they were just the most identifiable brand at that time.
Yeah.
But I can't think of another company right now where you've just gotten so used to saying, give me your pipe, I can use this interchangeable word that is actually a trademark. And I don't think we haven't seen that yet. That might happen in the future. I mean, if somebody can.
Well, go on, sorry.
Oh, no, go ahead.
I was just thinking with the whole graphics thing, it reminds me with them, because I remember when they were shut down,
Right.
whatever years ago. And then from what I understood, the law said, in a sense, that if you called it a graphics whatever water pipe, they called it a bong, which they made it fairly illegal because it had the bong word. And
Right.
So that term graphics, like if you're saying it now, that's the first time I've heard that name, dude, in probably 10 years, just because it was one of those things that people just stopped using it because of that. Like the K2 shit. There was like 100,000 different models and brands out there, but if you referred to this stuff as K2 and it was an undercover person, you were going to be getting arrested because if you're purchasing something illegal.
That would make sense. So I guess then we can say we have seen this concept in the pipe industry, but in a negative connotation, where the trademark name graphics immediately was associated with an illegal activity.
Yeah, exactly.
But yeah, they still have an active trademark. I mean, I don't know what their market share is, but they still have a registration with that great Joker skull gesture hat that we all are incredibly familiar with.
Yeah.
So okay, that's the first thing to think of is your trademark possible to get registered? Think of those four categories: fanciful, suggestive, descriptive, and generic. The second thing that you need to consider if you're going to try and register a trademark is there a possibility of confusion? This is not a clear-cut test and is done by a case-by-case basis and trademark-by-trademark basis. The USPTO examines every application for compliance with federal law and rules, and the most common reason for refusing a registration is likelihood of confusion between an already registered mark and the mark that is pending application. Now, confusion is determined by if the marks are similar, the goods and services of the parties are related as such that consumers would mistakenly believe them from the same source. The similar marks or related services by themselves are not enough to support a finding of likelihood of confusion unless a court has held that the mark is actually a famous mark. Each application is decided on its own facts. There is no simple mechanical test when used to determine whether a likelihood of confusion exists. So I got that directly from the USPTO. That is their interpretation is we know confusion when we see it. And
makes sense.
How that gets resolved in many ways is attorneys arguing back and forth and appealing to the USPTO of saying my client is not engaged in something that would be confused with this already registered or existing mark. Points that they use for considering confusion: the sound of the mark, the appearance of the mark, the meaning of the mark, commercial impression of the mark, similarity of the mark, such as city woman versus city girl. That could be possibly confusing. And then if there's similar classes or goods or services. So that's something you need to consider if you're going to register a trademark, is you need to be aware of if you're picking your name because it is playing off of a pre-existing name outside of the glass culture even, you're running the risk of getting one not registered now. But if you become higher visibility, you become more successful, you're running a risk of getting a cease and desist letter.
Yeah. Interesting. Now, if you say register and they deny your registration and you still use that name unregistered, is there going to be like a flag raised in a sense? Do all denials get a flag raised to make sure that you're not going to actually use that name for potential?
No. It's more so the USPTO. They won't police you. It is up to the independent entities. So this is the other thing. If you register a trademark, you have to protect your mark. You have to take the steps to do it. The USPTO won't do that. They'll give the decision of if the mark is registered or not.
Right.
And if the mark is registered and you do go into court, so saying I have an unregistered mark and I go into court and the other party is saying I'm infringing on their mark and they have a federally registered mark, there's already a presumption of ownership on their part. I have to prove that I've been using the mark longer than they have in order to show that I have a right to use the mark. And that, I just had the NFL pop up in the background. Weird. Sorry.
It's all good.
So the benefit of having the registration is when you're in court, you get more protection. And it is easier for you to police your mark because if you do end up going into court or when you write a cease and desist letter, you can say, here, I have this registration number. This is what the protection that is presumed that I have. You would have to show that you have some legal right to use it. Furthermore, I can now seek statutory damages for your infringement. And that's where the big money is. I mean, that's where you're going to find people going bankrupt for having a statutory infringement, or worst case scenario, or a lot less worse than going bankrupt. You find yourself in a situation where you've been operating a business for, we'll say, 3 years under this trademark and under this name. And now you realize I can't use this anymore, or I am going to have to pay statutory damages. And so now you got to look at your consumers and say, well, buy my product. I went from being something and now I'm brand X. I'm this new brand. Yeah. You should still buy my product. I know you're going to love it. Most consumers don't hang out like that. They don't keep purchasing like that. That's not how people move in the market. So
yeah, that's true.
That's something that's a very serious issue, though. Possibility of confusion is something that you really need to consider when you register a trademark.
No, something on the same lines, like the whole poor man copyright, poor man trademark thing, where you like mail it to yourself immediately once you design it or come up with it. So you always have it, in a sealed envelope, stamp dated, blah blah blah. So say like you did that, you never registered it federally. Someone else registers it federally. They take it to court. Does something like that hold up, or is the trademark, the registration, hold more than a stamped envelope?
So what you'd find yourself in a situation of is if you would beat them on the date, right? So you can prove that you were operating your trademark prior to their registration of a trademark. What they would not be able to do is they would not be able to stop you from using a trademark, and they would not be able to seek statutory damages. But what you would not be able to do is expand your trademark. You would have common law protection in the region that you're already operating. Also, you're going to have to explain to a court why something that is so valuable and essential for your business, you didn't take the steps to protect.
Yeah, makes sense.
And try to argue either I didn't know, I didn't care. None of these arguments really give a good impression that you care about your business and that you're operating with best business practices. So yeah, you would probably be, there are cases that I think there is an area in Africa, there's a country in Africa that McDonald's got late to the game of filing for McDonald's. And there was already a fast food chain or a burger chain operating as McDonald's, and they were denied because and I think they just took it on the chin and they said that they weren't going to operate. There's famous stories or famous trademark cases, even more locally, of someone operating a McDonald's in America, who the guy's name, I think, even was Ronald McDonald. And he had been operating as just a small family business for years. And they tried to shut him down, and he was still able to operate. He wasn't able to expand his business, but I don't think that was his business model anyhow. He just had a small family business. But so if you're already using it, and that gets into another interesting one. If you're using your last name, you do have a limited right to use your last name in your business. And if it happens to share the name with a famous trademark, you can't get shut down as easy. But also, I would never recommend a client doing that, because depending on how you want to operate your business, if you want to grow your business, that's not a great way to do it. Let alone if you're picking a trademark that you already know has a market presence, especially a pretty significant one. I recommend all my clients don't do that.
Yeah, absolutely.
Yeah. So the third issue, will you get it registered? This one, there's a little bit of a technical side, which if you are at a point in this where you're considering getting a trademark registration, go speak with an attorney. I have seen a number of issues come across my desk where someone goes with an online service that says they'll file their trademark for them at a discounted cost. You don't need an attorney. You can do this on your own, or we'll take care of it. And the quality of what the filing looks like is terrible. It's garbage. They submit a specimen that is barely readable. There will be issues with how they do the category, with how they do the description of the service of the product. And inevitably what happens then is you get something called an office action, which asks for a clarification of what the filing actually meant. And if you've used these services, you go back to the service and say, hey, I got this letter. Apparently my trademark isn't registered. What do I do next? And they say, well, you paid for us to register your trademark. We're not actually attorneys. We're not going to respond to your office action for you. And the federal government doesn't refund application fees. So now you're in a position where you've paid for a service. They've registered it. You're not getting your money back, and you don't know what to do. They don't tell you how to fix it. So if you would have started working with an attorney, it might be a little bit more expensive at the beginning, but you'll get the full service of, okay, here's what we do next. Here's how we amend your application. Here's how, and if you're familiar with trademarking, some people are. I've met people, especially in the design world, people seem pretty familiar with it. And you feel confident, do it on your own if you feel that way. But if you get to a point where you're actually responding to office actions, definitely seek out an attorney. It'll save you a lot of time. Depending on what you're trying to submit to the USPTO, you do run the possibility of committing perjury. So that's just something to have on your radar. And the other one that I would say also is if you're creating pipes for tobacco use, that is allowed. There's actually a specific category for it. And I've seen some of the businesses that I've mentioned before who are some of the, I think, more established pipe makers even file just under glass art, glass sculpture. That I think, and I would encourage people to consider doing that.
Yes, yeah, for sure. Yeah, so they don't require necessarily specificities on what you're doing. It's just kind of a general, generic thing.
The more specific you are in what you do, the better protection you have. Because the more detailed of a description of what you do, if there is the possibility of someone infringing on you, if it's general and it looks like what they're doing is close to what you're doing, but it's not, it's harder to say, well, this is specifically what I do. They're doing this specific act. Clearly there's infringement. Yep. When you speak in generalities, there's a lot more room to argue that, well, we're not actually doing the same thing. So, and if you're too general on the filing, you will get rejected by the USPTO just on that basis too.
Okay, cool. Good to know.
So, and then that moves us into the last area, special concerns for pipe makers. this is an interesting one. It touches on some of what we talked about in the last episode too, just because you do now have states that have amended their laws that the sale of accessories or cannabis accessories or modifications of criminal code where drug paraphernalia is no longer defined as utensils used for ingesting cannabis. So we're talking about Colorado, Washington, Alaska, and Oregon. You might want to start marketing your product where you're like, hey, look at people can legally consume cannabis, so this is what I'm making it for. That's still federally illegal. Mm-hmm. Even though if someone was caught, and I wouldn't be even caught, if they were stopped and they had cannabis on them and they had a pipe that you made, that's not illegal anymore if they're within the range and age and all for having the cannabis. So it's an interesting time in that regard, because I could probably, or you could file for a state trademark in those areas saying I make cannabis pipes, because there's both state and federal trademarks. And I would assume from talking to the really nice lady in the state of Washington at the trademark office that you would have one granted on that basis. So it's really confusing where now you have a state trademark that's registered with the state of Washington. If there's infringement, you still can't bring that. And if you registered it for a cannabis pipe, you can't bring that in federal court for infringement, because the federal court system still wouldn't acknowledge that you have a valid trademark.
Right. Huh.
So there's a big disconnection in that. I actually just read a really great article from International Trademark Association talking about how there's just a very big disconnect right now between the state and federal laws, where it's been fairly harmonious before, because most states have modeled their trademark offices off of the federal system. So
yeah, it's interesting. And then on that same note too, so if you do get the trademark in a legal state, you shouldn't or cannot, under recommendation, I guess, by whoever out there, that you shouldn't advertise in states where it's illegal recreationally.
I would, if you are in your business model, decide to pursue a state trademark where you're saying you're making these pipes for cannabis consumption, and that is the mark you register, I would not sell your work in any other state besides that state or states that were compliant. That is my thoughts. That's just my opinion. Other people might disagree with that. Just because you've identified that you are creating these pipes for cannabis consumption, and the definition of paraphernalia, one of the factors for testing it is what is the intent of the creator? What did they make it for? Now, if you created it for an artistic purpose or an expression, or you want something beautiful to sit on a shelf, or you created it for the intent to use it for tobacco, you arguably have passed that factor for, is this paraphernalia? You're positive it's not. But if you have a registered trademark and I was going to prosecute you, and you say, well, I'm selling cannabis pipes in Washington, but in Wyoming, these are tobacco pipes, I'd ask, well, clarify. Show me why they're different. Mm-hmm. You've registered and you've shown me your intent here, and let alone now you've also crossed state lines potentially with your shipping. Explain to me how it's one thing here and another thing somewhere else, because you had the volitional intent to register a trademark in the state of Washington. Why does that change now? You can't. It would be, for a really watered down sense, trying to double dip on what this is. It's like, oh, over here it's one thing, and now that we're in a different area, it's totally something different. Courts don't buy into that so easily. So that's something to consider. So I think if I was, I would be a little bit leery in registering state trademarks. I think there's a definite benefit for cannabis businesses, but I think for the glass industry right now, I would be a little bit hesitant to just identify in that regard. Yeah,
for sure. Yeah, so much gray area still.
Yeah. Well, most of the gray area is just that this is illegal, and
it's pretty big.
Right. Paraphernalia is still an issue. I mean, the international borders are still very much an issue if you are trying to ship internationally, or if you're a glass shop and you're trying to receive packages internationally. That's still, the U.S. customs are a big deal, and they will hold up packages, and it happens all the time. So
Yeah, it's unfortunate.
yeah.
Well, awesome, man. That was good stuff. It's hope everybody kind of catches on and takes notes and write this stuff down, and really think about what they're doing in their work and how they're creating it and who they're creating it for. Because as cutesy as we want to be with our work nowadays, sometimes it's not always the best thing to be super cutesy and go off these other ideas of other companies out there that are making stuff. But I guess with the trade. Oh, go on. I didn't hear about
You actually just reminded me. That was the last point that I wanted to say for special concerns for pipe trademarks in the pipe industry. The Instagram accounts that you're using, depending on the products you're using, your hashtags, if it is a trademark, are going to lead businesses to find you. And if you are infringing on their trademark, you are going to get a cease and desist letter based on that. There's a number of occurrences that I'm familiar with in the industry that have had this. I think one of the ones that comes to mind most recently was seeing the discussion about lava lamps.
Oh, yeah.
And lava lamps seem fairly generic to us because we're like, oh, yeah, a lava lamp. That's actually a trademark. And I know that there was a glass maker who is making lava lamps, and I think they're now called something like Party Lamp, some other name. But it's being aware of, if you are recreating things that already exist in the world, be cautious about using things that are actually a trademark, because I don't think we've seen one to fruition yet, but actually having a lawsuit on this basis, especially from an established company, would most likely devastate most glassblowers. Then just because this hasn't been an issue for the last 5 years as much doesn't mean it's not going to be an issue in the next 5 years. I think anyone who's living on the idea, well, but I've done this forever, that is not a good legal way to live your life. Just have that on the radar, especially if you are in the habit of recreating things that already exist, or that's part of your business model or your product line. Just be very aware of what you're calling those things, and especially how you're marketing yourself on Instagram.
Heck yeah. And when we get into the future episodes talking about copyright and stuff, I definitely want to talk about parody, that kind of ideas, because there's a lot of parody going on out in the industry as well. But the parody is like kind of a fine line it's been walking.
Oh, parody is a fine line too, where especially when you add in sales after the fact, like you really have to have all of that organized. Thinking about like Scary Movie and movies like that, where it's the entire basis of it is parody. You just got there's a lot to that. No, and I look forward to it. I think the copyright episode will be really interesting because I think there is a lot of room for copyright to apply to the glass industry in the future. We just need a federal shift, for one. And then two, we just need some glass artists who try to register their art.
Yeah.
And I hope I would like to see that happen. So.
Me too.
Yeah.
Maybe I'll take that jump one day.
I look forward to, and I need to do more research on that too. Because I have asked this to plenty of attorneys who have far more experience than I do, and I just keep getting scratched heads, usually from attorneys being like, I didn't know that this existed. And then, are you serious? They're selling pipes for that amount of money? And I'm like, yes, that's very much real and consistent. And then, well, yeah, I mean, that's a work of art, so that should be protectable. I don't know is consistently the answer that I get. So I think that's something to be investigated a lot more.
Yeah, I agree. Hell yeah.
So.
Well, once again, brother, thank you so much again for your time, and it's an honor to have you on again, and I'm looking forward to more episodes and giving everybody some insights to ways we got to really take care of ourselves as we grow as a real industry every year.
Yeah, and I thank you again for having me. I really appreciate it. I think the best practices for this industry is essential for the industry to go forward and especially to grow in a positive way. Just even in the last 3 years, I've seen so much growth and adaptation to what I would say is more traditional business practices that I think just having that awareness, especially for people who are just getting into the glass industry, know what you're doing beforehand, because it can save you a lot of time and a lot of problems down the road. I think, and this is not at my shameless plug part yet, which I'm going to do. But try to find attorneys you can work with. A lot of people I talk to, especially if they're, depending on the cultural background they have, they're only used to the idea of talking to an attorney if there was a criminal issue. And more, you can prevent a lot of problems if you talk to and get good advice before you're at that point, because otherwise it's just picking up pieces and trying to prevent, either a fine or a jail sentence. But you can potentially prevent a lot of that if you can find someone that you trust and has good representation beforehand. So, and I'm not saying me. What I'm saying is just find some assistance.